Good afternoon, everyone, and thank you for joining us at the final round of the 96th Annual William Minor Lile Moot Court Tournament. My name is Amy Vanderveer, and I have the privilege of serving as the president of the Lile Board this year. Before we get started, I wanted to go over a few quick logistical matters. First, at this time, please make sure that all cell phones, watches, and other electronic devices are set on silent. And second, while you are welcome to leave at the conclusion of the argument, we ask that you do not exit the room during the argument so as to not distract our competitors or the judges. I also have the privilege of introducing our distinguished panel today. Chairing the panel, we have Chief Judge Kevin Ohlson of the U.S. Court of Appeals of the Armed Forces. Judge Ohlson attended Washington and Jefferson College on an Army ROTC scholarship. After graduating from the University of Virginia School of Law, Judge Ohlson was stationed in Fort Bragg, North Carolina, where he served as a prosecutor and as an Article 32 investigating officer. While assigned to the 18th Airborne Corps, Chief Judge Ohlson parachuted out of a plane into 3 different foreign countries. Upon leaving military service, Chief Judge Ohlson became a federal prosecutor in Washington, D.C. He was recalled to active duty and deployed overseas during the Persian Gulf War, where he was awarded a Bronze Star. He later returned to his duties at the Justice Department, and he served in a variety of leadership positions during a career that spanned more than 25 years. He was ultimately appointed as Chief of Staff and Counsel to the Attorney General of the United States. He was nominated by President Obama to sit on the U.S. Court of Appeals for the Armed Forces and confirmed by the Senate in 2013, and he has been the Chief Judge since August of 2021. We are also joined by Judge Michael Scudder of the U.S. Court of Appeals for the Seventh Circuit. He joined the court in May 2018 following the retirement of Judge Richard Posner. Before joining the bench, Judge Scudder was a partner in the Chicago office of Skadden, Arps, Slate, Mager, and Flom, LLP. He served in the White House as General Counsel of the National Security Council, as well as the United States Department of Justice on National Security Team, and of the Department of the Attorney General as an Assistant United States Attorney in the Southern District of New York. He's a former law clerk to Justice Anthony Kennedy of the Supreme Court and Judge Paul Niemeyer of the U.S. Court of Appeals for the Fourth Circuit. For the last 10 years, he's taught national security law at the University of Chicago and also teaches a course in advanced federal jurisdiction at Northwestern University Pritzker School of Law. Finally, we are joined by Trevor Cox, a litigation partner in the Richmond office of Hunton Andrews Kurth, LLP, where he is a member of the Issues and Appeals team. He represents private and public clients in Virginia and federal appellate courts on a wide variety of matters, including issues of state and federal constitutional law. He also leads Hunton's State Attorneys General practice. Before joining Hunton, Trevor served for more than 4 years in the Solicitor General's Division of the Office of the Attorney General of Virginia as Deputy Solicitor General and Counsel to the Executive Division, Senior Appellate Counsel, and finally as Acting Solicitor General of the Commonwealth. As Chief Appellate Counsel of the Commonwealth of Virginia, he represented the Commonwealth and its agencies and officials in matters concerning the constitutionality of Virginia statutes and regulations, or in matters touching upon sensitive policies of the Commonwealth. In January 2018, he presented argument on behalf of Virginia in the United States Supreme Court in Collins v. Commonwealth of Virginia. He maintains a robust pro bono practice and is active in a variety of legal and nonprofit organizations in Virginia and beyond. He's a graduate of Harvard College, Harvard School of Law, and the University of Cambridge. Now I would like to invite another Lile board member, Mr. Sam Ellis, to come up and provide a brief overview of the problem for this year's final round.
As an inmate at Minor Correctional Facility, Michael Nelson donned a blue armband in protest of a prison policy and inspired other inmates to do the same. To suppress the protest, Warden Davis transferred Nelson to a Level 3 security unit and barred him from speaking with other inmates. In response, Nelson filed a Section 1983 complaint against Warden Davis alleging First Amendment violations. Nelson was subsequently released from prison and filed a supplemental complaint that reflected his new custodial status. Both parties moved for summary judgment. After finding that Nelson's First Amendment rights had been violated, the district court turned then to the question of damages. The court concluded that Nelson's claim was subject to the Prison Litigation Reform Act, or PLRA, which requires a showing of a physical injury to recover compensatory damages. Because Nelson had not alleged a physical injury, the court denied him compensatory damages and limited him to nominal damages. This case presents two questions of statutory interpretation regarding the PLRA's compensatory damages provision. First, is Nelson's suit still subject to the PLRA despite him no longer being incarcerated? Second, if the PLRA does govern this case, does the statute's physical injury requirement apply in a case alleging a deprivation of constitutional rights? While federal court of appeals are split over these questions, both are issues of first impression in the 12th Circuit. Please rise to welcome our panel.
Malia, Takei, counsel for the plaintiff appellant.
Baldwin, counsel for defendant appellee.
Nathaniel for the defendant appellee.
Please, everyone be seated. Well, good afternoon, everyone. Welcome to the court. We have one case today. Michael Nelson versus Richard Hayes. Counsel, are both teams prepared to argue? Very well. Granted. Please proceed.
May it please the court. Malia Takei, counsel for the plaintiff appellant. At the heart of today's case is whether a limitation on prisoner recovery applies to a non-prisoner. It does not, for three reasons. First, Mr. Nelson filed a supplemental complaint according to Rule 15D, informing the district court that he was no longer incarcerated. Second, nothing in the text of 1997 EE displaces Rule 15D, or standard pleading practice. And finally, this interpretation of the text is in line with the legislative history and congressional intent. Now, standard pleading practice helps clarify the proper outcome in today's case. Rule 15D establishes that parties are able to inform the court of any new facts or modifications of facts that occur after the timing of the initial filing. And this is permitted even if the initial pleading was defective in stating a claim or defense.
Counsel, I'd like to actually focus on a little different issue initially. Now, as you're well aware, Section 1997 EE flatly states, no federal civil action may be brought. Now, in your brief, you state flat out that that should not be read literally.
No, it should not.
And you cite the Supreme Court case of Jones versus Bach for that proposition. But didn't the court in that instance really cabin the reach of that? It was specifically within the context of rejecting an argument that the word action should be viewed as allowing for the dismissal of an entire claim when in fact it failed to meet the PLRA's requirements. Why should we take that same approach in this particular case?
Yes, Your Honor. Jones v. Bach is still applicable, even though it was focused on the word action in regards to Section 1997 EA. And that is because the Supreme Court and Chief Justice Roberts specifically called out the entire prefatory language of no action shall be brought as being boilerplate language. And they said that this entire prefatory language was commonly used throughout both the PLRA and several other statutes in order to introduce the language for the section. And here we see that is exactly the case for 1997 EE. That prefatory language of no federal civil action may be brought was used just to introduce this limitation on recovery for prisoners in context of the PLRA. So even though Jones v. Bach was about 1997 EA and was about whether or not the standard definition and common law definition of action was going to be used, it still is applicable and provides important foundation for the outcome in this case.
Well, that's all well and good for the United States Supreme Court to say that explicit language, in fact, is merely boilerplate and that it can be ignored. But what about our court, the 12th Circuit, where, as we all know, Justice Kagan said at a dinner on behalf of Justice Scalia, when it comes to us judges, we're all textualists now. Why should we look at such clear, plain language and without any guidance from the Supreme Court say that we should ignore that within this context?
As Justice Scalia stated, textualism doesn't require a literal reading of the text. It simply requires a fair reading of the text. And in this instance, we're not asking this court to rule out the word brought or this prefatory language entirely. We are just stating that it introduces this limitation on recovery and introduces a general prohibition in this specific instance.
The difficulty that I have with your position is, I understand the Rule 15D argument, but it's the supplemental or amended complaint was filed in the same action. So when you read the language of the statute where it says no civil action may be brought, the civil action, yes, there was an amended complaint in it, but the action was brought when Mr. Nelson was incarcerated. I mean, that's the problem. That's the difficulty that he has.
Yes, Your Honor. I have 2 points to that. First, the word brought could theoretically be read to impose this pre-filing statutory precondition to suit. And in that case, that literal definition of brought at the common law does mean the commencement of a lawsuit. We agree with that. But it does not mean that according to standard pleading practice, you cannot substitute and file a supplemental complaint when there is this pre-filing requirement.
Okay, but do you agree that an amended or supplemental complaint, supplemental is the language used in the rule, it's still filed in the same action?
It is still filed in the same action.
And so the way Congress has worded that statute is that no civil action may be brought. It's still all in the same action. So I grant you that he could accept a voluntary dismissal or effect a voluntary dismissal and refile. And if it's a timely refiling, that issue goes away. But the amended complaint, it sure seems to me, was filed in this action.
For this, we can look entirely to the purpose of the PLRA, which was to promote judicial economy and not to pose an impediment to meritorious litigation. And in this case, requiring a plaintiff like Mr. Nelson to dismiss or withdraw his action and file an entirely new action just impedes meritorious complaints from going forward. We also see that this just requires duplicative actions. The purpose of supplemental pleadings and Rule 15D was to ensure that parties were able to get as complete an adjudication on all of the issues between the two parties. It's not meant, we're not supposed to be required to withdraw and file an entirely new action.
How about the language, counsel, that follows, that no civil action may be brought by a prisoner? How does that affect your argument?
Yes. In this case, we can plainly see that Mr. Nelson, as he is no longer incarcerated, falls outside of the definition of a prisoner as established under 1997 EH. And the intention of the PLRA and all of its different sections was specifically to target prisoner litigation. It was not meant to target non-prisoner litigation or litigation by individuals who once were a prisoner and then were released. Mr. Nelson plainly falls outside of the different buckets that the PLRA was meant to target and the types of cases it meant to target. In this specific instance, we also see that Mr. Nelson raised a meritorious complaint. As the district court said, appellee plainly violated his First Amendment rights. But in this instance, the PLRA serves as a filtration system, and it's meant to make sure that frivolous litigation is not allowed to proceed, to prevent the bogging down of federal courts from handling frivolous actions like Eighth Amendment complaints about receiving chunky peanut butter instead of smooth peanut butter, or complaints about receiving a bad haircut. That is not the type of complaint and not the claim that Mr. Nelson brought before you today.
Counsel, how about situations where the individual plaintiff's status changes again? Person goes back to prison. What are we to make of that situation? Is the complaint valid or not? Is this on again, off again kind of analysis appropriate?
That hypothetical was put forth in Harris v. Garner, but it's important to remember that Rule 15D does not grant supplementation at any whim of any party. It is required that the district court judge grant a party permission to file a supplemental pleading. And they're allowed to deny this pleading if they believe it's going to cause undue prejudice, undue delay in pursuing the action, and also if they believe that the action itself is frivolous.
So why doesn't that make this all appear arbitrary? The district court judge can simply say yes or no without any reasoning for allowing the supplemental filing to affect the 1997 EE filing. Where's the uniformity that we should be looking at in terms of the application?
I think the uniformity would be in following standard pleading practice, which is where if this text of the statute doesn't expressly displace Rule 15D or supplemental pleadings and other procedural practice, then we follow what actual federal rules of civil procedure establish. And in this case, that would allow supplementation and status changes. And it doesn't result in different varying outcomes because still the district court judge is constrained in their denial because they have to put forth a reason. They can't just deny in the abstract.
Ms. Takei, a few minutes ago, it seemed like you acknowledged that the best reading of brought is not a literal reading, correct?
Yes, Your Honor.
Okay. That's usually a tough position to advocate from saying, you know, the language doesn't mean what it says. So therefore, how would you articulate in a sentence or two what it is you want us to hold with respect to that language?
Yes, Your Honor. We would want you to hold that the word brought does not displace the federal rules of civil procedure and that supplemental pleadings are still allowed to adjust a prisoner's status under 1997 EE. That would be the holding we would ask for today. I think it's also important to note that
it seems like you're arguing two sides to the issue when it comes to boilerplate language. You said it's boilerplate language consistent with what the Supreme Court said. But by the very nature of boilerplate language, doesn't it have to mean that the terms there are the ordinary meaning of those terms? And what you've just articulated is not the ordinary meaning of the word brought. Judge Scudder was just indicating it. Brought means initiating a claim. So how can it be that we should view it as boilerplate language and we shouldn't take it literally at the same time that you're saying it's boilerplate language, but we should not view the terms within that section to carry their ordinary meaning?
Either way, reading brought as boilerplate language and just an introduction to this limitation on recovery, or to read it literally as imposing this temporal requirement, supplementation under Rule 15D is still going to be permitted. And this is because under Chisholm v. Romer and Jones v. Bach, the Supreme Court has stated that if a statute is to deviate from federal rules of civil procedure and standard pleading practice, it has to be express. And we see no such express displacement of those rules within the text of 1997 EE. So regardless of how you view brought, and regardless of whether or not you see it as imposing this pre-filing requirement, it still is permitted to allow parties like Mr. Nelson to file a supplemental pleading. And to see this, we look to the Supreme Court cases Matthews v. Diaz and Missouri v. Wolf. In both of those cases, the statutes had a pre-filing requirement. In Matthews v. Diaz, this was jurisdictional. It required a plaintiff to file and submit an application to the Commissioner of Social Security before initiating a pleading. In the specific case, Matthews v. Diaz, the plaintiff did not submit an application and had not received a rejection from the commissioner at the time they filed their initial pleading. But that did not mean they could not pursue their case. In that instant, the Supreme Court explicitly said supplemental pleading would allow this case to still move forward, even though there was this pre-filing requirement.
Counsel, there's a couple other sections of 1997E that use the word brought or the formulation brought by a prisoner. I think you've mentioned one of them. Another one is 1997ED1. that limits the situations in which attorney's fees are authorized. What is your position as to the impact of your argument on that section? Is it your position that there's now no limitation on attorney's fees because this would not be an action brought by a prisoner?
I think our position advocates for a consistent definition of the word brought, either deeming it boilerplate as the Supreme Court did, or saying that brought does not displace the federal rules of civil procedure. And with regards to 1997 ED1, we specifically believe that there could be supplementation of that non-prisoner status, but by the words of that statute, and same with 1997 EG, I believe, that specifically poses this more firmer, more mandatory language than what is present within the section of 1997 EE. So it does make it a little bit harder of a case, and it's not technically what's present before us today. But I do believe that in those circumstances, just based off of the fact that there is no express displacement, as in 1997 EE, then there would be permission to file a supplemental pleading.
What do you think Congress would have to say to satisfy this clear statement rule that you're urging us to adopt?
Yes, Your Honor. We see two examples in the PLRA besides 1997 EE, and that would be in 1997 EG and 1997 EC1. Specifically, in 1997 EG, we see that the Congress explicitly and expressly displaced Federal Rule of Civil Procedure 8B. And for those reasons, we ask that this court to reverse the holding of the lower court. Thank you.
Counsel for Defendant Appellee.
May it please the court, my name is Ben Baldwin, counsel for the defendant appellee, Warden Richard Hayes. This case is about the appropriate remedy to a prisoner under the Prison Litigation Reform Act, or PLRA. And the PLRA applies in this case. Specifically, the text and statutory purpose of Section 1997 EE makes clear that a plaintiff's confinement status at the time of the filing of their initial complaint is determinative of whether the PLRA applies. In so doing, the text of the PLRA displaces the normal operation of Federal Rule of Civil Procedure 15D. And now, even if Rule 15D were to apply here, Mr. Nelson's supplemental complaint cannot cure the initial filing defect he had here because it cannot change the historical fact that he was a prisoner when he filed his initial complaint. Now, turning to the text of the statute first, the relevant part of 1997 EE provides that, quote, no federal civil action may be brought. And the operative word there is brought. And as the foregoing discussion just said, brought is quite clear. Brought means brought. It refers to the initial filing or commencement of a lawsuit. And we can look to other courts' interpretations of other provisions of the PLRA to confirm that understanding. Take, for example, 28 U.S.C. 1915G, which describes the three strikes provision of the PLRA, which determines whether or not a prisoner is able to take advantage of informa pauperis status when they are filing a complaint. Here, a number of courts have determined that the informa pauperis status and the application of the three strikes rule is determined at the initial filing of when that prisoner makes whatever relevant action, whether it be an initial action or an appeal. Take, for example, 1997 E subsection A. Other courts, including the Sixth Circuit in Cox v. Meyer and in Barger v. Wright, have also recognized that brought means brought. And the only thing that we need to look at is the plaintiff's confinement status at the time when they are filing their initial complaint.
So can you please address this issue of whether Federal Rule of Civil Procedure 15D applies or not? It seems clear from the Supreme Court that they expect in these type of cases that the standard pleading practice will control unless the PLRA specifies that it doesn't. Where would this court find the specification within the language before us that, in fact, 15D is inapplicable?
So we can take a look at other provisions of the PLRA to see that, yes, in other provisions there was clear abrogation and clear reference to the Federal Rules of Civil Procedure. You will not find any express reference to Rule 15D or amended or supplemental complaints in this provision. However, we can look at the overall statutory framework and take a look at the statutory purpose to understand.
Now, it's a situation where if Congress was aware, as we must assume from the rest of the statute, that they were knowledgeable about the applicability of 15D and what the issue might be there, why wouldn't that cause us to conclude that 15D applies? Because they didn't specify in 1997 EE otherwise.
Because we can take a look at the actual, the phrasing that is used here in this particular provision of the statute and focus solely on that word brought to understand that the precondition to suit that is established here cannot be changed by subsequent pleading. Because we are solely focused on that initial filing status, any supplemental complaint referring to some sort of change in status by the plaintiff would make no difference. And the reason why that kind of makes sense here is the 11th Circuit in Harris versus Garner addresses this. Yes, supplemental complaints can add certain facts, but it is the substantive requirement that is set forth in the statute that determines whether or not those facts make any difference. And because they use that brought language, the only fact that could ever make a difference is the fact of the plaintiff's confinement status at the time of the initial filing.
Why wouldn't we think about, in a lot of statute of limitations cases where there's an amended complaint filed that relates back, we see that constantly. Why should we think about this as a situation that's any different? The plaintiff left prison, no longer incarcerated, brings that fact to the court's attention in an amended pleading. Why doesn't that relate back? How is it any different than a statute of limitations situation where some material fact is added?
So in a lot of statutes of limitations cases, the underlying purpose of the statute of limitations is to ensure that that claim is brought within a timely manner so that certain evidentiary value is not lost. Here, the statutory purpose underlying this substantive requirement is the introduction of a disincentive for prisoners filing frivolous lawsuits.
Sure, but his status changes. So you'd have to acknowledge if he had waited until November of 23 to file the lawsuit when he was no longer incarcerated. There's no problem with that.
No, there is no problem with that.
Okay, so how is that substantively different than him getting out of jail and saying, I'm no longer in jail, I'm no longer subject to the limitation, let's go?
Because the concern is that a prisoner would game the system in some way.
Yeah, I don't understand that. What are you worried about?
The concern is that a prisoner would take advantage of the lower barriers to entry of filing a lawsuit while they are a prisoner versus kind of facing that higher opportunity cost differential once they have left prison. And so when Congress enacted the PLRA, their focus was on reducing the number of frivolous filings by prisoners. And to do that, they introduced a number of substantive requirements that would discourage prisoners on the front end from bringing lawsuits. And they recognize that because prisoners have reduced filing fees and availability.
You may be creating a straw man, though, because this is the furthest thing from frivolous litigation. So I don't really see somebody in a situation here like Mr. Nelson gaming the system.
Well, that is correct, but the rule that would be established here would apply more broadly than just to Mr. Nelson's case. And in enacting the PLRA, the Congress was trying to balance two different things. First, reducing filings while also improving the quality of prisoner lawsuits. And yes, they established strong substantive requirements with the understanding that certain meritorious claims might be required to be refiled after a prisoner had left prison in a situation similar to Mr. Nelson's here.
Is there any real world, any empirical indication that this abuse is going to occur? It seems very odd to me that I don't know where the incentive would come from to persist with frivolous litigation when released from prison. Where's that incentive come from?
The incentive would be if the prisoner sought to just muddy up the waters and or vindicate their right or vindicate their grievance just by continuing in the court system against their original jailer, which we could see in certain cases, just given the fact that a number of frivolous filings were made in the past. Counsel referenced, the availability of certain different types of peanut butter and many other concerns that were raised by Congress in the legislative history that accompanied the PLRA, where prison officials were deeply concerned about these kinds of frivolous lawsuits continuing.
But you agree, counsel, that Congress was not concerned with reducing frivolous litigation by former prisoners?
That is correct.
Just current prisoners?
Yes. The PLRA clearly does not apply to somebody who is no longer a prisoner. And to return to a discussion that was had earlier, in this case, Jones versus Bach does not control here. As Your Honors mentioned earlier, Jones versus Bach was a case that was dealing solely with the question of the meaning of the word action, and yet this is a case that turns on the meaning of the word brought. And to take from that the kind of the boilerplate language characterization would be, as Justice Thomas recognized in his dissent from certiorari in Wexford versus Garrett, or in Wexford Health versus Garrett, excuse me, that would be dicta taken by courts for far more than what it was worth. Instead, what Jones versus Bach actually recognized in certain circumstances is that the PLRA does depart from the normal operation of the federal rules of civil procedure in certain circumstances. And here we also...
I don't ask you to concede this point, but let's assume for a moment that this court concludes that Federal Rule of Civil Procedure 15D does apply. Can you prevail?
Yes.
And how?
Because it does not cure the original defect in this case, which is that he was a prisoner when he filed the original complaint. Just the fact that he has changed his status somehow does not remove that status that he originally had when he was a prisoner. And here, that would still mean that he is still not alleged a physical injury, and therefore the substantive bar would apply in this case. And we can take a look at that in other circumstances where, a supplemental complaint can cure many things, but it is not a panacea for all kinds of defects. Take, for example, diversity of citizenship cases. There, the diversity of citizens is determined at the time of filing in order to reduce those concerns about supplemental complaints being used to kind of game the system so that parties could take advantage of favorable court rules or favorable rules in a certain domicile. And there are a number of other cases, too, that plaintiffs have relied on, both in their briefs and some of their arguments today, where allowing a supplemental complaint to continue a case would defeat the underlying statutory purpose behind a substantive requirement set out in a statute. Matthews versus Diaz is one of those examples. Now, Matthews versus Diaz...
I'd like to revisit an issue, though, that Judge Scudder raised in terms of, you were referring to barriers to entry,
Yes.
opportunity costs. How does that really play out, though, in the real world? If you've got, as you've articulated in your brief, you may have prisoners who have a lot of time on their hands and would come up with these claims. But couldn't they hold them in their back pocket until they walked out the door and then just file outside the PLRA otherwise?
Yes, and that was the purpose that Congress was attempting to effectuate. Because the thinking was that by the prisoner kind of keeping those claims in their back pocket, the increased opportunity cost after they left prison would be a disincentive for filing frivolous lawsuits.
And what exactly are those opportunity costs?
The opportunity cost would be the associated higher cost with filing the lawsuit in the first place, because prisoners have access to a lower filing cost, reduced filing fee. The assumption would be that higher filing fee, at least at the outset, would discourage prisoners from filing, accompanied with the other court costs.
It sounds an awful lot like you are asking this court to impose a regimen where people who don't have money are put at a disadvantage, a distinct disadvantage, compared to someone who does.
In this case, we're just attempting to follow the purposes that were outlined by Congress when they were attempting to enact the PLRA. And their primary purpose was in reducing frivolous lawsuits. And so their concern there was just establishing a system of substantive requirements that created these kinds of disincentives for filing.
You keep coming back to frivolous lawsuits, but I think, don't you have to start in this case from the premise that this is the furthest thing from frivolous litigation? It's a meritorious claim. So you're building your argument about how to construe the statute from a premise that's entirely counterfactual here.
Well, here we're concerned about creating a broader rule that would extend beyond Mr. Nelson's case. So Mr. Nelson here, as the lower court recognized, does have a meritorious claim.
Right, but 1997 EE is not meant to foreclose 100% of prisoner-related litigation. I mean, Congress would have written that statute in a completely different way.
That is correct, but it operates in conjunction with the other provisions of the statute to create an overall framework that is intended to reduce prisoner filings. And so returning to an earlier example about Matthews versus Diaz, Plaintiff's counsel here referenced Matthews versus Diaz. It was a case in which a plaintiff had filed a case or had joined a civil action prior to filing a claim for Social Security benefits and prior to that being rejected by the Secretary of Health and Human Services. There, it made sense for the court to allow a supplemental complaint because it did not thwart the statutory purpose of allowing these kinds of claims to be resolved quickly by allowing that case to be continued. In contrast, allowing the case, or we can also take a look at another example of, in the PLRA context at least, of Cox versus Meyer, which is a 1997 EA case. There, the Sixth Circuit recognized that the plaintiff had failed to exhaust any of their administrative remedies prior to bringing the court case, and there it would not have made sense to allow for a supplemental complaint to cure that initial filing defect, because there, the statutory purpose of 1997 EA in providing notice to prison officials about the kinds of prisoner grievances that were being alleged in the case prior to that entering into federal court would not have been served. In contrast, a later Sixth Circuit case, Maddox versus Edelman, did allow a prisoner to supplement their complaint because in that case they had actually exhausted some of their claims prior to a supplemental complaint alleging additional claims, and therefore it made sense in that circumstance to allow that case to continue because the statutory purpose would be furthered by allowing that case to proceed. Here, in contrast, Mr. Nelson did not satisfy the physical injury requirement, and therefore allowing his case to proceed would thwart the statutory purpose of reducing prisoner filings and forcing them to meet that substantive requirement.
Not to beat a dead horse, but to go back to what Judge Scudder was talking about, you're relying a lot on what the purpose of Congress was rather than simply staying grounded in the text. If we take that approach, why, based on all the entries from the congressional record that we have in front of us, isn't it clear that they were really aiming at sifting out frivolous complaints? And that is not what we are dealing with here. So doesn't focusing on the purpose of the statute really undermine your position?
No, because I think they were considering, and Your Honor, I might run out of time soon, so may I conclude may I answer your question? The focus in general was to both reduce frivolous lawsuits and improve the quality of prisoner suits. And there they adopted a general rule of reducing prisoner filing. So here we can take a look at both the text and the purpose of the statute in conjunction to adopt a straightforward rule that Section 1997 EE should apply in this case. Thank you.
Counsel for Plaintiff Appellant on Issue 2.
May it please the Court, Jake Flansburg, Counsel for the Plaintiff Appellant. This case presents the question of whether Congress intended to functionally bar an entire class of constitutional injuries without ever using those words. The district court reasoned that it did, and we ask that you reverse today for 3 reasons. 1, text. 2, precedent. 3, purpose. As it was quite popular during the preceding issue, I'll continue our conversation with the text. Section 1997 EE provides that no federal civil action may be brought for mental or emotional injury without a showing of prior physical injury. Now, conspicuously absent from what I just said was any mention of constitutional rights, of liberty interests, or of free speech harms. It necessarily follows that a claim like Mr. Nelson's, a claim for free speech harms, is not encompassed by Section 1997 EE's plain text. And it has long been held that a statute should not be interpreted to cover subject matter that it simply does not cover.
Now, counsel, in your brief, you refer to this harm done to the plaintiff as being, quote, intangible. Why then wasn't the district court judge correct in his ruling when he said an intangible harm is merely, quote, a species of emotional or mental harm?
For 2 reasons, Your Honor. One, the common law meaning of a mental or emotional injury, and two, our conceptual understanding of what that is today and why it excludes intangible free speech harms like Mr. Nelson's. Starting with number one, at common law, mental injury was understood to encompass a particular and at times closed universe of claims. It included things like nervous prostration, like anxiety, like pain and suffering, like dignitary harms. What it did not include, what the pages upon pages of common law treatises that we reviewed in advance of today made no mention of, were constitutional rights or liberty interests akin to those asserted by Mr. Nelson, which bleeds into our conception of what a mental injury is today. For in plain language, we would hardly say Mr. Nelson is asserting a claim for mental or emotional injury. That is because the record is silent on Mr. Nelson's mental or emotional reaction to the events that unfolded. By way of contrast, it was clear on the ways in which Mr. Hayes deprived Mr. Nelson of his free speech interests. As a result,
on page 19 of your brief, you say that when a plaintiff's free speech rights are impinged, that mirrors a loss of liberty at common law. But it's only in the next page that you try to cite to legal authorities and pull that together. What are you really pointing to that says that a loss of liberty is the same thing as a situation where free speech rights are impinged?
So we are not saying it is the same thing, Your Honor. We're saying it's derivative of, and I think that's an important distinction because, as you point out, they are not the same thing. And because it's derivative of, that's in accord with the court in Carey's construction not to woodenly apply or to ossify the common law, but instead to adapt the common law. And on the note of citations for that precise proposition, if that's a concern, in Dellums v. Powell, the court connected the loss of liberty and the free speech interests, indicating that the compensation principles for one inform the other. Similarly, in Palco v. State of Connecticut in 1937, Justice Cardozo, writing for the court, explained this link. He stated, loss of liberty was newly understood to encompass something more than mere freedom from physical exemption. It had expanded outwards to include things like freedom of speech, indicating that this is concretely derivative of a loss of liberty and that perhaps explains the structural analogies between the two claims.
But wasn't the justice really saying that he was recognizing this as a broader panoply of liberty interests? It doesn't mean that there is necessarily any connection between the two, or as you phrased it in your brief, that one mirrors the other.
I think that one thing that just occurred to me as you posed your question is that a helpful way to think of this could be as a sliding spectrum. On one side, we might have mental or emotional injuries, and on the other side, we might have a loss of liberty. And the question then becomes, in light of the court's instruction to adapt the common law, which of those two things free speech harms more closely mirror? And it seems based off of that opinion that even though it might not fit like a glove, so to speak, it is the closer adaptation. Mr. Nelson's injury is closer in kind to this common law loss of liberty than a mental or emotional injury.
What your adversary says that I think you need to respond to or address is that if we announce the rule that you're urging, every single prisoner is going to come in and recast alleged injury in constitutional terms.
Yes, Your Honor. We are not asking this court to recognize the capacious one-size-fits-all constitutional injury for any prisoner plaintiff to claim in subsequent litigation. Rather, what we are asking is derivative of what the court said in Carey, that constitutional rights do not exist in a vacuum. They exist to protect downstream interests. And our conception of the instant case is that the right on one hand is a First Amendment right, and the downstream interest, on the other hand, is a free speech harm. And the narrow holding we are asking for is a finding that that free speech harm is compensable. And that has important implications for other cases. Take, for example, a due process claim. Indeed, take the facts of Carey, which involved a threadbare procedural due process violation. The court there indicated that the only actual injury that could flow from that would be a quote-unquote feeling of unjust treatment. That's a situation wherein, under our reading of the statute, Section 1997 EE would still require a showing of physical injury, indicating that the inquiry we are asking for is an examination of what the underlying interest is, whether it is uniquely constitutional or whether it is something that is perhaps reducible to mental or emotional injury. And in the latter instance, the physical injury bar would still be operative, thus assuaging opposing counsel's concerns about a flood of litigation. And on the notes about—
How would you see your position as interplaying with the Section 1983 decision of the Supreme Court in Memphis Community School District versus Starchug, where it said that the subjective perception of the importance of a violation of a constitutional right cannot serve as the basis for compensatory damages, that there has to be proof of actual injury? Do you view PLRA as being completely separate from 1983? We should not look at what the Supreme Court said there?
We believe you should look at what the Supreme Court said there. And the court in Statura's concern was with the idea that awarding damages based off of the quote-unquote abstract value of a constitutional right was not compensatory. So in turn, we have offered you two metrics of damages that we believe are compensatory for this actual free speech injury. Metric number one would be the estimation of damages. Metric number two would be the presumption of damages. I'll start with the estimation of damages. It is entirely consistent with the common law for a jury to ascribe a pecuniary value to a non-pecuniary thing. Indeed, that's precisely how a loss of liberty was compensated at common law. And as opposing counsel has raised concerns about workability, I'm going to be exceptionally mechanical about how this would unfold. Step number one is that a juror would ask what their individual experience is with this underlying intangible interest. That in turn provides a baseline valuation. Step number two would then involve multiplying that underlying deprivation by time, which indicates that that metric of damages is 2 steps removed from what was deemed impermissible in the Statura case. Step number one is different in kind, and step number two is different in scale. And even if you find that metric of damages unpersuasive, it's worth noting the court in Statura also greenlit the presumption of damages if 2 conditions are met. 1, a harm is likely to occur. 2, a harm is difficult to establish. I'll start with the first prong.
Before you do that, counsel, could you give us any assurance that your argument and your position, if we were to adopt it, would not allow future plaintiffs to smuggle in other kinds of injury through the same kind of analysis that you're proposing?
Of course, Your Honor. I think one thing that serves as an important limiting principle is the fact that prisoner litigation unfolds in 2 parts. Part number 1 is to ask whether there is a rights violation. We've cleared that hurdle here. But in other cases, that first step might still be at play, indicating that any asserted right that's inconsistent with the penological goals of a prison, as the Supreme Court has recognized, would be unable to advance. So that's one limitation. And I believe the due process example I raised earlier about an instance wherein this is reducible to mental or emotional injury would be another instance where in Section 1997, EE's physical injury bar would still be operative. So of course, there's always going to be room for subsequent playing around in future cases, but there's still these underlying limitations in this actual injury requirement by the court and that first step of the analysis.
So, for instance, the dignitary or dignity injury that you cited before, you think that's reducible to emotional or mental injury?
Yes, Your Honor.
Okay. Are there other kinds of injuries that you can think of that we should be concerned about that may not neatly fall in one camp or another?
I don't know if there are any that do not necessarily neatly fall in one camp or another that I can readily identify, but I can identify that perhaps the inquiry gets a little bit more nuanced with respect to Eighth Amendment cruel and unusual punishment claims. And in his opening remarks in the legislative history, Senator Dole indicated a concern with this. And there's a Seventh Circuit opinion, Robinson v. Page, wherein a prisoner plaintiff in essence stated, I have lead in my drinking water, and the court grappled with, is this a mental injury? Is this something different? Is this something physical? And so there are going to be those edge cases wherein this doesn't seem to neatly fit in any category, indicating that yes, a case-by-case analysis does have some of its pitfalls, but at the same time, it's an analysis worth engaging in. Because Congress, when it enacted the PLRA, was repeatedly clear. Yes, it was concerned with reducing frivolous filings, but it was not concerned with indiscriminately reducing filings. Senator Hatch, on the floor.
See, what seems odd to me about your position is if you take the point that you just articulated, and your adversaries agree with that, Congress is trying to drive down frivolous prisoner litigation, and by extension believes that could happen just by driving down the sheer number of filings that way. Both sides seem to agree on that. It seems mighty odd, though, for Mr. Nelson to be arguing that the very same Congress that had that objective would be silent in the statute as to constitutional claims. Because what else would Congress have expected from federal prisoners? It's not going to be state law claims litigated in federal. So it seems odd against the backdrop of that very clear objective that Congress would choose to be silent on constitutional injury.
Yes, Your Honor. It's our position that Congress was concerned with the underlying injury in the sense that it was concerned with claims that are reducible for mental or emotional injury. So we agree that this is not exclusive to the common law and that the statute wouldn't only be operative in these kind of state law claims that you've expressed a concern with, but rather that it would be operative in cases involving due process, in cases involving the Eighth Amendment cruel and unusual punishment. And if there are any reservations about why I'm raising those precise examples, it's because Congress did. Senator Dole, in his opening remarks, indicated that the uptick in prisoner litigation arose out of claims over 1, cruel and unusual punishment claims, and 2, due process claims. That rationale, however, does not extend to the First Amendment because First Amendment harms are plainly unlikely to be accompanied by a physical injury, which means that subjecting them to a physical injury bar is tantamount to ruling them out altogether.
What about like an excessive force claim? You mentioned it before, but it could have both a physical component but also more of an abstract constitutional injury. What is your position about whether you can disaggregate them for purposes of your analysis?
If I may have leave to answer your question, I think that an excessive force claim would inherently involve physical injury in most, if not all cases, indicating that those types of claims do not arise very frequently in this context for the precise reason that they already meet Section 1997 EE's hurdle. If there are no further questions, it is for the above mentioned.
Thank you, counsel.
Thank you.
Counsel for defendant.
Thank you, Your Honors, and may it please the Court. My name is Nathaniel Glass, appearing on behalf of the defendant appellee, Warden Richard Hayes. It's clear from that discussion that the outcome of this case is going to turn on how we characterize the harms that Mr. Nelson suffered. The parties are in agreement that if this is a non-mental or non-emotional injury, he would not be barred by the physical injury requirement. We also agree that if they are mental or emotional, he would be subject to that bar. And on those grounds, the lower court correctly held that the only actual injury that can serve as the basis of his recovery here is mental or emotional in nature, in the form of a dignitary harm that he experienced when his First Amendment rights were deprived.
Now, you referenced the ruling from the district court. There's something that's very striking in that written ruling from the district court judge, where he wrote that applying 1997 EE in the manner that you are urging us to, where there's a physical injury requirement to constitutional harms, he says that, quote, it will no doubt restrict recovery for some meritorious claims, not just frivolous ones. So you are urging this court to take ambiguous language in a federal statute and knowingly interpret it in such a manner where we would be restricting meritorious constitutional claims?
I would respond to that with 2 points, Your Honor. The first is that 1997 EE, by its very nature, will never apply to frivolous claims. That's because it's a bar on recovery. So that means if a plaintiff is subject to the statutory scheme, they have already won on the merits. So Congress intended this to cover meritorious claims. And Congress did so through clear language. It said no federal civil action. It didn't say no federal civil action except for constitutional violations. It was clear that this would apply across the board when the basis of damages would be a mental or emotional injury, which is what we have here. And I'm going to focus on three main reasons why the plaintiff's position should not win out. The first is that loss of liberty is not truly distinct from mental or emotional harm in the sense that they paint it as. The second is that even assuming there was some element of loss of liberty that was distinct, stretching it to cover free speech harms would eradicate the actual injury requirement that the Supreme Court has outlined in Carey and Statura. And finally, the idea that, as they describe, mental injury at common law had a common understanding. But this statute reads mental or emotional injury. And mental or emotional injury indicates a broader category, such as the dignitary harms that Mr. Nelson suffered. Now, beginning with loss of liberty. When courts are awarding damages based on a loss of liberty, they're not awarding the abstract interest inherent in the deprivation. They are saying that every time someone is deprived of their liberty, two harms are so bound up in that deprivation that they're presumed to flow from that. And the first was a purely mental or emotional harm of loss of enjoyment of life. And that is a psychic harm that is best described as mental or emotional. The second would be loss of time, which the better reading of that is that that refers to kind of economic damages of someone's value of wages in the workplace. And so every time that someone was deprived of their liberty, courts were saying it's so likely that these two harms would follow that we're not going to require actual proof of those injuries. But if you break those down, one of those is mental or emotional, and the other is kind of pecuniary in nature. And here, the plaintiff has not made out any such grounding. And to the extent that he did, one of those would be barred by the physical injury requirement.
I mean, what Mr. As I read his allegations, what Mr. Nelson, correct me if I'm wrong here, is alleging is that during the 3-week period that he was in the higher level of security, that he basically lost all communication ability. Why the warden insists that that is mental or emotional harm. And in responding to Mr. Nelson's arguments to the contrary, you just say, well, to the extent he's trying to differentiate anything, what he's talking about is just something that has an abstract value. What's abstract about that?
It's abstract in the sense that if you ask a jury to compensate the deprivation of the right, they would have to take into account the society's impact, society's valuation of that right. It's the idea that a jury cannot rationally determine what the value of that right is. They would have to ask two questions. One could be, what did Mr. Nelson think of this right? How much did he value it? But that would be getting in his head.
So suppose, hypothetically, of course, that the warden says, for the next 3 weeks, all Christians are prohibited from praying, categorically. And our hypothetical plaintiff is Christian. Would that injury be abstract in your view?
It would be mental or emotional in the sense that it would manifest in the minds of those plaintiffs. They would experience distress at the inability.
But that, according to who, the defendant or the plaintiff?
I'm sorry, I don't follow.
So when you say that, you're arguing that on behalf of a warden defendant, right?
Yes.
But why can't a plaintiff come in and say, it was a complete deprivation of liberty, we lost our prayer hour, we lost this, we lost that. You know, it's a freedom protected by the First Amendment that we lost.
Because the Supreme Court has been explicit that the mere constitutional deprivation itself cannot be the base of damages. In those instances, when the only actual injury that they can prove is the constitutional violation itself, then nominal damages are appropriate, which is exactly what the lower court awarded here. But I think what you're getting at is that it seems like an actual injury still flows from that in the sense that they were deprived.
It's definitely injury for Article III purposes.
Yes, it's an actual injury for standing purposes, but the PLRA imposes a bar. I think a lot of the cases that they cite, particularly Dellums or Brooks, these are pre-PLRA cases. Those are instances where the court has said that if a person is deprived of their free speech rights, that is an actual injury that is compensable. But what those courts don't do is take the second step and say, what kind of injury is that? Because these are pre-PLRA cases. They weren't forced to spell out whether that was an emotional harm or a non-emotional harm. And we're of the position that the only actual injury, the only basis that a jury could rationally conclude the value of the damages from.
Mr. Nelson here, during that 3-week period that he was locked down, he could have lost all contact with his family, right? And perhaps in a deposition he would testify, no, it didn't cause me an emotional breakdown. or any mental harm, but, you know, I sure miss talking to my kids. I sure miss talking to my spouse. And that's a freedom that I had that was taken away from me. But no, I didn't have a mental breakdown. Why isn't that compensable?
Because that is still a mental or emotional injury. The term mental or emotional injury is not synonymous with mental or emotional distress. Congress didn't use the word distress. It opened the universe of mental or emotional harms to be broader than that. And in certain common law treatises, harm to primary family or relationships were considered a compensable type of harm. But over time, as mental or emotional injury became a broader category, it was subsumed within that. And so Mr. Nelson would still be alleging a mental or emotional harm. I think it'd be hard-pressed to characterize the missing that you feel from not talking to your family as something outside your own mind or your own emotions. It's at its base trying to reflect the value that you place on the ability to talk to your family in an emotional sense.
So please, no.
Counsel, do you have any evidence that Congress intended for plaintiffs not to be able to allege constitutional, well, let's say First Amendment injuries in this context? I mean, given that they so rarely would manifest with physical injury, is there anything you can point to that would lead to that conclusion?
I would point to the fact that they're not prohibited from raising these claims. They're not prohibited from receiving relief on these claims. They're prohibited from receiving compensatory damages on these complaints. And that is very different. They still have a forum for the resolution of their more meritorious claims. They have the ability to receive an injunction, to receive the vindication through nominal damage of saying your constitutional rights were violated, and if they do it again, we're probably going to award punitive damages. So they still have that recourse through the federal courts. I would also say that Congress shouldn't have to be more explicit than the statutory language it chooses. And plaintiff points out that there's no legislative history backing up that the plain text means what it says, but it doesn't have to. The plain text means what it says, and it says no federal civil action may be brought for mental or emotional injury without proving a prior physical injury. Congress chose expansive language to accomplish its goals without specifying that this didn't apply to constitutional harms. And I want to turn to kind of the line drawing problems that you...
The D.C. Circuit's opinion in a ref fit into this, where the court said it's difficult to believe that Congress would afford immunity to prison officials even when they commit blatant constitutional violations, as long as there was no type of physical blow, is the way the D.C. Circuit wrote that. What is your reaction to the ref decision?
I would say that blatant constitutional violations will largely be basis for punitive damages. If they are so egregious and so blatant as to
so if we
reach
take
that
out
bar.
the word blatant, where does that leave us?
That leaves us with the fact that Congress, I think the D.C. Circuit might not have wanted Congress to have done this, but that doesn't change the fact that they used the language that they did. And the D.C. Circuit is concerned that without compensatory damages, deterrence won't be achieved. But frankly, that is a judgment call that is left to Congress. And Congress, I think you can't escape the plain language of the statute. And it says no federal civil action may be brought. And that indicates that Congress may have struck a balance when it was writing this, and it said it's okay if maybe some people don't receive compensatory damages, even for their meritorious claims. That's a balance that we are striking. And if a court has a problem with that, I think it's best to resist the temptation to change it through judicial opinion, but rather leave it to the legislative branch to correct. Now I want to turn to the kind of line. Oops, sorry.
Can I ask you one question?
Of course.
One point you make in your brief, you give up quite a bit in your brief. It surprised me a little bit, where you carve out property damage. And so, now you may do that because of the statute, but you have to acknowledge then in a hypothetical where an inmate had property arbitrarily destroyed by the prison staff because, say, they were upset with him wearing a blue armband or what have you, that claim can go forward.
Absolutely. And that's in line with our reading of the text. This doesn't say that no action may be brought without a physical injury. It says no action for mental or emotional damages. And so maybe a hypothetical will be helpful. I think if we're talking about a free exercise claim, where someone is trying to exercise their religion, and they have their religious text seized and destroyed by the prison warden, under our theory, they would be able to recover for the value of that property that was destroyed, because that is not a mental or emotional injury. The jury would not have to get inside the mind of the plaintiff to say, how much do they value their religious exercise? They would be saying, what is the value of this religious object? How can we make them whole? Which is the absolute goal of compensatory damages. Under their approach, that plaintiff could merely reframe that and say, I suffered a loss of liberty to my religion, which I think we would all agree is no less fundamental in our society than speech is. And they would say that this is a fundamental right that is analogous to loss of liberty at common law, and therefore I can reframe this and say, I was suffered a loss of liberty to my religion, it's distinct from my mental or emotional harms, voila, it's compensable. And so that's the difference between our approaches, that we would look to verifiable facts that can be proved or disproved that could serve as the basis of damages.
So you spoke earlier, I think, about the deterrence value. I mean, do we think that the warden is going to be deterred from future unconstitutional activity by the awarding of $2.50 in total, including attorney's fees?
Yes, the attention that was brought to this incident through the judicial involvement, the fact that if he were to do this again, he would stand very close to punitive damages as a matter of law because he's a repeat player. This is the idea that if he does this again, the courts are going to be on notice that this is repeat action, and therefore that deterrence is achieved. He has a judicial order saying you violated this person's rights, and he's, as a result of that, less likely to do that again.
Why shouldn't other prison officials be emboldened if we were to take the approach that you wish us to take?
Because
Knowing that you can violate constitutional rights of prisoners and you're likely to get away with it.
Because there are circumstances where the deprivation of constitutional harms in the prison setting will give rise to compensable damages. For instance, the most egregious ones are when the prisoners receive beatings by the prison guards. That would not be barred by
You
this.
just don't beat the prisoners, you violate their other constitutional rights.
No, because
Intangible.
those people are still subject to the injunctive relief, to nominal damages, and to punitive damages. And so those options of remedy still exist, and to the extent that you are worried that this isn't the optimal level of deterrence, that remedy lies with Congress rather than the courts to amend a rather clear statute. And I want to talk about what a jury would have to do to reach a damages here. They mentioned that merely having a per diem calculation would help, but multiplying an error over a course of days doesn't make the error go away. And the error that I'm talking about is they would have to get some valuation of the deprivation itself, and there's no way to rationally do that. And if you look at the common law analog,
Ask juries to do irrational things all the time in terms of making all sorts of calculations where they are pulling these things out of the air. If you talk to jurors, they go back there and they deliberate, and they typically really understand what they're doing. They're just coming up with numbers. So why is there a distinction here where you're viewing this as a grave impediment to recovery here as compared to what we ask of jurors all the time?
because here we have an additional bar that we'd have to police juries on two accounts. We have to police them, one, and say, make sure they're not basing this on mental or emotional damages, and two, make sure they're not basing this on the abstract value of the right itself. So that, combined with the fact that Congress was concerned about judicial economy and not burdening the federal courts, means that we should be hesitant to impose a rule that would reopen jury verdicts and require constant policing. With your concerns about general jury awards notwithstanding, I think that problem is not unique to this statute, but it shouldn't be a reason to avoid a straightforward rule that intangible injuries should not be divorced from the actual injuries that they create.
I see your time has expired.
Yes, thank you.
Thank you. Rebuttal.
May it please the court, I have 2 points I'd like to make on rebuttal, one for each issue. As it's top of mind for all of us, I'll continue with the second issue and then move on to the first. Opposing counsel casts the availability of punitive damages or injunctive relief as a limitation on wardens like Mr. Hayes. But as footnote 17 of the Aref case makes clear, those remedies might be available as a matter of form, but they are infrequently available as a matter of function. Indeed, the instant case is illustrative of that point, particularly with regard to punitive damages. Mr. Hayes siloed Mr. Nelson for weeks on end in level 3 confinement to quote-unquote shut him up. The district court still found this did not meet this high bar of punitive damages. If it's not met in this case, it is difficult to environ what cases it is going to be met in. Moving on to the first issue, opposing counsel largely casts Section 1997 EE as a kind of substantive requirement, and in some respects that's true. a limitation on recovery is substantive in nature, but how that limitation on recovery is imposed is also procedural, indicating that the time at which a particular action is brought is a procedural component of all of this, and it is one that Rule 15d supplementation can still affect. If there are no further questions, it is for the above-mentioned reasons that we ask that you reverse the court below today. I thank you all for your time on this evening.
Thank you. The case is now submitted. The court thanks counsel for both sides, and the court will stand in recess for deliberations.
That our judges have left to deliberate, I ask that you join me in giving a big round of applause to our finalists.
Court is back in session. On behalf of my colleagues, I would like to thank you for your stellar performance here today. And we now believe it would be constructive if each judge provides his own views on the actual oral argument. Mr. Cox.
Thank you, Your Honor. So my perspective is a little different from my colleagues here, being an advocate myself and not a judge. So maybe it makes it more meaningful to you all, maybe not. But I can say I was very impressed, as I know all of us were, with the level of advocacy delivered here. And particularly, nobody seemed really that nervous. And it occurred to me, I remember reading a lot about preparation for oral argument and how people arguing at the U.S. Supreme Court would understandably feel nervous. And in previous arguments in the courts of appeals, people obviously know the material, but at the U.S. Supreme Court, it's a different level. And so I remember one advocate saying that their argument at the U.S. Supreme Court was the least nervous they had been. And the reason why was because they were so prepared, they knew the subject so well that they had no reason to be nervous. And I got that sense from all of you. You clearly were very conversant with the material, which came across in a variety of different ways, and so you're all to be commended for displaying that. It can be difficult in a case that has so many different issues with a lot of different nuances to demonstrate that command of the nuance and recall the case that stands for the proposition that you want to cite, but all of you did it, and you did it very well. The other thing that I want to compliment everyone on is your demeanor. I mean, demeanor can capture a lot of different things. When you're an oral advocate, it's in some ways a very calculated performance, but you don't want it to come across either as calculated or a performance. Ideally, it should be a conversation at a very elevated level, of course, but still a conversation in which you're trying to educate, you're responding to questions, and I thought all of you achieved that standard as well. So kudos to everyone.
Thank you, Mr. Cox. Judge Scudder.
Thank you very much. Thanks to the law school for the invitation to be here. I had a daughter that graduated last May, undergrad here, but it's my first time to the law school. And I had a terrific day. You have a wonderful law school here, and you're all very blessed to be a part of it. So thank you for the invitation. You did a terrific job, each of you. You're very well prepared, articulate, knew the material very well, and just kind of rolled with the argument. I can tell you from Chief Judge Ohlson doing this every day, you would each be very welcomed in the Seventh Circuit and would be in very good standing right now if you did nothing else to improve. So you are way, way along the way in becoming very effective oral advocates. So congratulations. I've got 3 tips for you, or 3 suggestions. Oral argument. One, I think, kind of shortcoming that you see in preparation, really wasn't on display today, but think about it when you're preparing, is it's very easy to focus on your strongest arguments. And I don't even think you have to do much work to get ready, because if I asked any of you, tell me why you should win, you would know it right off the top of your head and you would do fine with it. I would really concentrate your oral argument prep on the weakest card in your hand and what the hardest formulations of the questions are you can get about the weak links in your case. Because that's what you want to prepare around, and that's what you want to be ready for. Judges that are prepared are going to pick up on that, and that's where they're going to press you. And so that's my suggestion there. Second tip about oral argument may seem a little bit odd to you, and that is don't forget your brief. The first impression that appellate judges form of cases is based upon reading the briefs that way. And that impression is one that stays with us as we do it. And so it's very difficult to overstate the importance of your written work. The briefs that we received coming into this were terrific. Really, really good. And just double down on your writing. There's no world where being a good brief writer is going to hurt you as a lawyer, and certainly not as an appellate advocate. That doesn't exist that way. And the one thing that we will see from time to time is people that are not good brief writers, or they just don't devote the time and effort to it, somehow persuade themselves of a narrative that they can save the case in oral argument. I think that's a risky proposition. And I would just really focus on your brief writing because you're so far along on the oral advocacy side of things. And third is find a way to practice. And let me suggest that a very good way is, as you start your legal career, is to really commit to pro bono work. There's a lot of people out there, there's a lot of causes out there that could really use good advocates. That's a terrific way to help clients in need or issues in need, and it's a great way for each of you to get on your feet and get in front of courts. Thank you again for the opportunity to be here.
I would certainly echo the comments of my colleagues here today. I just thought that your performances were truly and sincerely exemplary in every regard. Superb preparation that was clearly obvious in each and every sentence that came out of your mouth. You had an exemplary command of the law and the facts. You really, even with the questions that we posed, you could always tie it into the law, the specific cases, the facts that supported your position. You were very deft at handling the questions that we did pose to you, even when we tried to throw you off a little bit. I think it's also very telling about how comfortable and in command each of you was when you got up there. The comments were made about nerves. It's tough not to have nerves in a situation like this, but I can tell you, you all really handled it extraordinarily well. In terms of a broader phrase, when I have advocates ask for guidance from me, the one thing I say to them is never take the phrase oral argument too literally. Because when it comes to the concept of argument, who are you arguing with? The strictures of the actual appellate advocacy, you're not really arguing against the opposing side, and it would be a misstep to argue with the judge who is in the position to decide your case. So what I say to them is, instead, really view this as a moment for oral persuasion rather than oral argument. The approach you should take, which each and every one of you did, is to take the approach of, come, let us reason together, and I will show you why my side should prevail. And I just thought you were straight on target in the way that you handled that. In fact, being an alum of the law school here, it did me proud, it made me feel good, made me feel great to be back here on grounds. And I couldn't help but think of the words that I think are now in Clay Hall, if I'm not mistaken, where each and every one of you exemplifies those words in terms of the performance you put forward here, where it says that those alone may be servants of the law, who labor with learning, courage, and devotion to preserve liberty and promote justice. To have such fine attorneys as the four of you, and I'm sure the other soon-to-be attorneys out there, the legal profession is going to be all the better for it. So I thank you. It was a privilege to have participated in this moot court competition here today. Now, it is my privilege to announce the winner of today's argument, as well as to announce the best oralist. As my fellow judges would tell you, it was a difficult decision. It was a close decision. And I hope that you will keep that in mind if your names are not about to be announced. But the winner of the 2024 William Minor Lyle Moot Court Competition are Malia, Takei, and Jake Flansburg. Our heartiest congratulations. Well deserved. And the winner of the 2024 Best Oralist Award here at UVA Law School is Nathaniel Glass. On behalf of all the judges, we just want to wish you the very best in what we know will be exceptional legal careers. So the court will stand adjourned until further order of the court.